All right, this is Strickland v. Strickland, case 22-7289 DM. Both parties are present. Ms. Strickland is being represented by Ms. Wolfram. It's a motion by Mr. Strickland, an objection to the friend of the court recommendation. Sir, what date is this that you're talking
Your Honor,
objection to?
may I explain the procedure here?
Yeah, because all I'm seeing is there was a friend of the court recommendation before. There was an order entered in this case not too long ago about that objection.
Yeah, so so what happened is the friend of the court recommendation, he objected. That hearing was held in front of Judge Hillary, where he denied it as to the parenting time aspect, which entered as recommended, but changes, like his objection was sustained with regards to the child support.
Yeah,
he has now
children.
chosen to object again to all of it, but I would offer that that's improper. The only thing he could object to was the recalculation, in my opinion. But
yeah, if the judge has already ruled on it, you don't get to just keep objecting to it.
Yeah, I mean, I'm not a lawyer, Your Honor. I don't,
But
know
you're
that.
held to the same standard if you're going to represent yourself.
Okay, well, so Your Honor, I mean,
Is
again,
there a new UCSO that's been put out yet based on
yes,
him,
Your Honor.
3 kids and stuff?
Yes.
Okay, and have you seen that, sir?
I have seen that, and so I objected to the child support because of the fact that the first time it was too high, like I couldn't afford it, and
That's not a proper objection. It's either the calculations are or not. Are you objecting to the new one? Are the calculations in it correct?
yeah, no, I don't believe that they are correct, and
Then-
I am objecting to that one as well.
All right, then we'll have an evidentiary hearing, but if you're wrong, I'm going to charge you attorney's fees.
Okay.
That's simple. Ms. Wolfram, anything else you want to add?
No, Your Honor.
I can't enter the UCSO that I don't even have in front of me if he's going to object to it based on the friend of the court recommendation. But I am going to say that if his objection is, because I can't pay that amount and stuff like that, I'm going to charge him your attorney's fees for doing it.
Understood. My
If the-
understanding from his objection is that's exactly it. So I'll prepare a brief and for the record for the court.
Yeah, you don't have to prepare much of a brief, but if you're just going to say you can't afford it without a deviation factor that fits in, I'll find it to be frivolous because you've already been granted some of your motion. And this is a frivolous motion for most of it here because you're objecting to something that's already been determined.
So, Your Honor, if I can explain, so at first it was $600, and I said that was too high, and then they had made them. A friend of the court had made the mistake of only putting in 2 of my other children that I take care of full time, and so then they added a 3rd child, and then they also added in the fact that I get Social Security benefits for those children, and now they're expecting me to pay $840, which is more than what it was to begin with.
The calculations are the calculations. They are put into the computer, and the state of Michigan says how much. If you think you're going to say, I can't pay that because I just can't afford it, you're not going to win this case, and you're going to end up paying attorney's fees on top of it. It's not about that. If they have the correct number of children and everything, your correct income, then so be it. And if you collect Social Security for those kids, they'll include that in.
Right.
Not going to be just because I don't want to pay that amount of money.
It's not that I don't want to pay it. It's not. It's just that right now I do not have a job. I'm currently working. I'm currently in the process of being vetted for a job right now. And
We'll deal with it at the time. We'll set up a very short evidentiary hearing regarding child support. And I've already put on the record that if this becomes this kind of an objection, that it's I just can't pay it. I don't want to, or that kind of stuff. I just can't pay it. I'm going to charge you. You've had a hearing on this. They've corrected your child support order based on your objections from before. You then filed this objecting to everything which was already taken care of except the child support new UCSO. And so I can't enter it without having a hearing, but if it comes down to that, don't expect to get out of this scot-free. You'll be paying for her attorney's fees as well.
I mean, I just don't see where they in any of my rent. I don't see where they've added
They
in.
don't take rent out of it. They don't consider rent. You can go out and rent a 10,000 a month house, or you can rent a 500. It's money that comes out before you have other money to pay. You've got kids you've got to pay for. That's it. Okay.
Yeah,
That's the first thing. And you live off the rest of the money. As long as it's appropriately calculated, I don't care how much you have as a car payment. I don't care that, because it doesn't affect anything. There are certain rules, and I suggest you talk to an attorney, because they are the rules. If you can't meet a deviation factor, which I don't see any that you meet at this point, then it is what's going to be put in there, and you're going to pay attorney's fees too. We'll set an evidentiary hearing.
I mean,
An evidentiary hearing, if she shows that her costs, I'll give her a money judgment for that, and you will also end up, as far as I'm concerned, being your wages garnished and stuff. You can't come in here and just claim ignorance and this kind of stuff. Then go get some help through an attorney.
I mean, I can get help through an attorney. I mean, I can't afford that. I can't afford the $840 a month to begin with. I mean, I can't afford.
If 840 is the correct amount, you're not gonna be happy with the outcome. We'll set up a very short evidentiary hearing on this to check out the amount, probably half hour to an hour at the most.
We don't have to do that.
Person.
That's fine. I mean, if that's what, this is going to come down to, and I'm going to have to end up doing that. And if that's what you're saying, then we don't have to do that. But the thing is,
Are you withdrawing your objection then?
yes, I'll withdraw it.
Right. Then we'll enter that order, and there's nothing left to deal with. Okay,
I guess I can start paying. I can start paying in September when I start getting paid money. But that's as soon as I can start paying. I don't have any other money coming in except for that right now. The Social Security benefits that
you
I
will
mentioned.
withdraw your objection. I've got that. Ms. Wolfram, if you want to just do a, shortest order saying that he is withdrawing his objection, and that the uniform child support order dated, whatever it is, because I don't even have it. Okay.
I'll have the new one from the front of the court. They sent me a clean copy, so I'm not sure why you don't have it, but I do have a clean copy I can send.
If you would enter that, we'll get it out right away. Thank you, everybody. We're adjourned.
Thank you.
Number 6.
All right, well, that went just well. Okay, so
You're
let's
still
chat.
on. Hello.